Greetings, OACP members, and welcome to another installment of Quick Takes, what you need to know in under 2 minutes. I want to begin by just telling you that I'm looking forward to seeing many of you this next week at the OACP OSSA Fall Leadership Conference. It's scheduled for Wednesday and Thursday of next week. And if you haven't registered yet, it's not too late. We have a great conference planned, and so I hope you will take time, register, and enjoy the conference with us. For today's quick take, I want to make sure you're aware of a recently decided Court of Appeals case because it has immediate impacts on your officers and the work they do. Now, I want to encourage you to seek guidance from your agency legal counsel, and I want to give my usual disclaimer that the information I'm sharing here should not be considered legal advice or counsel. On May 12th, the Oregon Appeals Court overturned a lower court decision in Box v. State of Oregon. The basis for the case involves a situation where OSP troopers had probable cause to believe a crime was committed, and they went to the suspect's home to make an arrest. The court found that their actions, which included hiding in trees on the suspect's property, going past the front door into the curtilage, were a trespass because they had no warrant and no warrant exception for doing so. In the ruling, the court wrote, given the undisputed fact that the troopers' warrantless entry, the troopers trespassed unless that entry was authorized by exigent circumstances, the need for emergency aid, or express or implied consent. Thus, the question before us, said the court, is whether there was a genuine dispute of material fact as to whether any of the above conditions existed, and if not, whether either party is entitled to summary judgment as a matter of law. The court then considered each condition in turn and concluded that 1, there wasn't evidence that the troopers were required to act swiftly to prevent danger to life or serious damage to property, or to forestall a suspect's escape or the destruction of evidence. In other words, no exigency. And the court also concluded that there was no evidence that Mr. Box, the man that was involved in the case, gave his express consent for either trooper to enter, and that there was no dispute of material fact as to whether the troopers had implied consent. There was no indication that they had either. The troopers ended up shooting and killing the suspect, and the court allowed the case to go to the jury on the theory that the troopers' trespass was the cause of the shooting and the suspect's death. This is a significant change in the law. Now, I want to let you know this case is on appeal to the Oregon Supreme Court, but as you know, for now, it is binding law. In order to avoid personal and agency liability, officers should be aware of this case and should be extremely careful not to trespass, i.e., going past the no trespassing sign or going into the curtilage, that area that's connected to a person's home, unless they have a warrant exception, or implied or express consent. Now, I'm going to send you a follow-up email regarding this case, along with the case site, so you can read the case for yourself. But I want to encourage you to pay attention to this case. As additional information is available, I'll provide it to you. And until next time, thanks for taking time for this quick installment of Quick Takes. Thanks and have a great day. Bye-bye.